Hi everyone, welcome back. In this session, we are going to continue with the Viva Voce discussion, and we'll be discussing about some of the topics such as Consumer Protection, Specific Relief Act, Negotiable Instrument Act, etc. Once again, this is only few of the important topics. Now, first we'll start with selected topics from Consumer Protection. The Longman's Dictionary of English Language defines consumer as one who purchases goods or services. Similarly, according to Oxford English Dictionary, a consumer is one who purchases goods or pays for services. The Oxford Advanced Learners Dictionary also defines the consumers as a person who buys goods or uses services. However, whereas a consumer, according to the Collins English Dictionary, is a person who purchases goods and services for his own personal needs. Now, the objectives of Consumer Protection Act. 1. To provide protection to the consumer rights. 2. Speedy and simple redressal mechanism. 3. Civil court proceedings in consumer matters. 4. Consumers can directly file the complaint. And 5. Very least court fee is introduced. Now, what are consumer rights available? So that is the right to safety, the right to information, the right to choice, the right to basic needs, the right to consumer education, the right to representation, the right to redress, the right to healthy environment, etc. Now, with respect to some of the important terms and definitions in Contract Act, according to Section 2, Clause H of the Indian Contract Act, a contract means an agreement enforceable by law. So that is Section 2, Clause H of Indian Contract Act 1872. A contract means an agreement enforceable by law. So contract needs agreement plus the enforceability. Now, essential elements of a valid contract. That is discussed in Section 10 of the Indian Contract Act 1872. All contracts are agreements, but all agreements are not contracts. The agreements which possess the essential elements of contract is called valid contract. Now, Section 10 of the Indian Contract Act 1872 deals with essentials of a valid contract. The essential elements of a valid contract are: the first one, offer; second, acceptance; third, lawful consideration; fourth one, creation of legal relationship; the fifth, free consent between the parties; the sixth, competent parties to the contract, that is competency of the parties; then the seventh one, lawful object; eighth, possibility of performance; ninth, agreement not expressly declared void; 10. Fulfilling legal formalities; and the 11th one, agreement and registration. So if you summarize the 11 essential elements here, that is, there should be an offer, this offer should be accepted, and there should be a lawful consideration, and it should have a lawful object. The contract shall be for a lawful object and with a lawful consideration. Now, this should create a legal relationship, because only if it is enforceable, it becomes a valid contract. So, there should be a legal relationship. And the consent which the parties give should be free consent. And these parties should have the capacity to competency to make this contract, or capacity to make the contract. And it should not be something that cannot be performed. It should be possible to perform this contract, and even if all these conditions are met, it should not be something that is expressly declared void by the law. Then the legal formalities should be fulfilled, and the agreement and registration should be there. So these are the essentials of a valid contract. So oral contracts are valid, but it will be hard to prove it. If there won't be a solid evidence to prove it, it will be hard to prove the existence of a contract. But oral contracts are also valid unless it is expressly said by the law that there should be registration. Now, the classification of contract. Generally, contracts can be classified based on the enforceability, mode of creation, etc. Major types of contracts are based on formation, it can be said as express contract and implied contract. Then based on enforceability, it can be said as valid contract, void agreement. You never say void contract. It is void agreement, voidable contract, unenforceable contract, and illegal contract. Now, based on the method for formation, it is formal contract or simple contract. Based on the extent of performance, it is an executed contract or executory contract. Then, based on obligation, it can be unilateral contract, bilateral contract, or multilateral contract. Now, so that is the classification of contracts based on the formation, enforceability, method of formation, extent of performance, and on the obligation. So once again, with respect to contract, there is no void contract, there is only void agreements. A contract which subsequently becomes a void, that is an unenforceable contract or a voidable contract. So, and once again, the voidable contract is not the same as unenforceable contract. A contract can become unenforceable due to subsequent changes. That is the doctrine of frustration. Then voidable contract is there was some kind of no free consent or coercion or something. There is something lacking in the essential, and it can be made void at the instance of one party. That is, a voidable contract is considered as valid until it is made void. But there is no void contract, there is only void agreements. Now, with respect to some of the important topics from Specific Relief Act, that is in 1963. The Specific Relief Act has 42 sections in total, and it is a part of procedural law. It is a form of relief that is purely equitable in nature and equitable in origin. So, Specific Relief Act is purely equitable in origin. The different kinds of specific reliefs are: the first one, recovery and possession of property, recovery of possession of property. Then the second, specific performance of a contract. Then the third, rectification of instruments. Then the fourth, rescission of the contracts. The fifth one, cancellation of instruments. The sixth, declaratory decree. And the seventh will be preventive relief. So there is agreement for sale and sale. Agreement for sale is not the same as sale. Sale is a concluded deed, concluded contract, but agreement is a promise to sale. It's like an offer. The agreement for which the ownership of a property is transferred on a future date is called agreement for sale. The person who is agreed to deliver the property is called vendor, and the person who purchases the property is called the purchaser. Now, sale deed. The agreement for which the ownership of a property is transferred to a person after receiving consideration is called sale deed. The parties are vendor and purchaser. Then, gift deed. Now, gift deed is discussed in section 123 of Transfer of Property Act. The agreement for which the ownership of a property is transferred to a person without consideration is called gift deed. So, in contract, we learned that there should be a consideration, lawful consideration for the essentials of contract. But in case of gift, there is no money consideration. It is here the consideration is the natural love and affection the one person has for the other. Now, the person who delivers the property is called donor, and the person whom the property is delivered, to whom it is delivered, is called the donee. Then we have mortgage deed. The transfer of property for the security for a debt is called mortgage deed. So when the transfer of property is for the security for a debt, then that is mortgage. The person who transfers the property is called the mortgager, and the person whom the property is transferred, to whom it is transferred, is called mortgagee. Now, pledge, the transfer of movable property. So with respect to mortgage, it is immovable property, and pledge here the transfer of movable property for security of debt. So that is the difference between mortgage and pledge. Mortgage is also that property is transferred for security for a debt. In pledge also the property is transferred for a security of debt. But mortgage, it is a immovable property. Pledge is a movable property. Now the person who transfers the property is called the pawner in pledge. In pledge, the person who transfers the property is called the pawner, and the person to whom the property is transferred is called pawnee. Now lease deed, the transfer of right of enjoyment. So in lease, it's right of enjoyment that is transferred, only right of enjoyment. The transfer of right of enjoyment is called lease. The person who transfers the property for enjoyment is called lessor. The person to whom the property is transferred is called lessee. Partnership deed, two or more persons jointly performs a business and agreed to share the profit and loss equally or percentage wise is called partnership business. So two or more persons jointly forms a business and they agree to share profit. It may be equally or percentage wise depending upon the investments or contribution they made. That is called partnership business. The partnership business is collectively known as firm. Now will. Will, it is a document of a person's wish to dispose his property after his death. It can be altered or cancelled at any time when the person is alive. The person who makes the will is called the testator. Now, the person who benefits is called the beneficiary or legatee. Now, the power of attorney. Power of attorney is an authorization to appoint another person to do or to perform all or any one of the acts or to manage and look after any property for and on behalf of him. The person who makes power of attorney is called the executor. So it may be to perform all or any one of the acts or to manage and look after the property of an executor. When an executor authorizes a person to perform the task, it is power of attorney. That document which authorizes the person and the person to act on his behalf is called power of attorney. It can be complete, a general power of attorney, or a special power of attorney. Now, the person in whose favor the power of attorney is made is called the power of attorney holder. Now, contract of indemnity, that is in section 124 of the Indian Contract Act. This comes under special contracts. Contract of indemnity. A contract of indemnity is a contract where one person promises to save other from the loss caused to him by the conduct of the promises himself or by the conduct of any other person. The person who gives a promise is called indemnifier, and the person to whom the promise is given is called the indemnified or indemnity holder. So for example, if A is saying that if B doesn't pay you the debt he owes to you, I will pay it for you. So this is said to C. Here B is the person and C B owes debt to C. Now, if C doesn't give, then A is guaranteeing that A will give. Now, contract of guarantee. A contract of guarantee is a contract to perform the promise or to discharge the liability of a third person in case of his default. The person who gives the guarantee is called the surety. The person whom it is given is called the creditor. The person in respect of whose default that guarantee is given is called the principal debtor. So, what is the difference between indemnity and guarantee? For an example, in a partnership there was a loss. Partnership firm ABC, where the partners are A, B and C. They occur a loss with company and they owe a debt to company D. The D claims it from A alone. A alone pays the entirety of the debt to the company D. Then A shall be indemnified because A is shall be indemnified by B and C. B and C should pay their shares to A and A can move to the court for the C. So that is indemnity. And guarantee is that a person says, I guarantee you that A will pay the rest of the money to C on this date, and if he doesn't do it, if he defaults, I will pay the entirety of it. So A is saying that if B defaults in paying the debt, A will pay the entirety and discharge the liability. So that is guarantee. Now, contract of bailment, that is section 148 of Indian Contract Act. The contract of bailment is the delivery of goods by one person to another for a particular purpose upon a contract. And after the purpose is accomplished, the goods shall be returned or otherwise disposed of according to the direction of the person delivering the goods. It is a contract between two persons. The person who delivers the goods is called bailer, and the person to whom it is delivered is called the bailee. Contract of pledge or pawn, that is discussed in section 172 of Indian Contract Act 1872. Now, pledge is the delivery of goods, that is a movable property, as a security for a debt or the performance of a promise. The person who delivers the goods is called pawner. The person to whom it is given as is called pawnee. Section 172 of the Act defines pledge as the bailment of goods as a security for payment of debt or performance of a promise. That is called pledge. So pledge is a form of bailment, but the purpose here is security for payment or the performance of a promise. Therefore, bailment of goods is as a security for a debt. If immovable property is given, the transaction becomes mortgage. And then we have agency, that is discussed in section 182 to 238 of the Indian Contract Act 1872. These are considered as special contracts. So, indemnity, guarantee, bailment, pledge, agency, all these are special contracts. An agent is a person employed to do any act for another or to represent another in dealing with third persons. This definition is given in section 182 of Indian Contract Act 1872. The person who appoints an agent is called principal. Contract of agency is defined as the employment of one person by another in order to bring the latter into a legal relationship with a third person. So that is with the agency. Agency is discussed in section 182 to 238. Then we will move on with some important topics with respect to Negotiable Instruments Act. Here, a negotiable instrument means an instrument by delivery of which the legal right to money secured or represented by it is transferable from one person to another. So, A owes some money to B, and there is a negotiable instrument between A and B. So, this instrument is held by B, saying that A owes him some amount of money. But when B transfers this instrument to another person C, then the effect is that A owes this sum of money to C and not B. So that is transferability, and that is the effect of negotiable instruments. And in Negotiable Instruments Act came in 1881. According to section 13 of the Act, negotiable instruments means promissory note, bill of exchange or check payable either to order or to bearer. So three kinds of negotiable instruments are discussed, that is promissory note, bill of exchange and check. And how is it payable? Either to order or to bearer. Now, promissory note is discussed in section 4. If it is a negotiable instrument, according to section 4 of the Act, a promissory note is an instrument in writing containing an unconditional undertaking signed by the maker to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. So it is signed by the maker and it is a promise to pay certain sum of money, and to whom? Only to or to the order of a certain person or to the bearer of the instrument. The person who makes a promissory note is called the promisor or maker, and the person to whom it is made is called the promisee or payee. Promissory note made by two or more persons is called joint promissory note. Then, bill of exchange, section 5. It is a negotiable instrument. It is used to finance business transactions. According to section 5, the Act, bill of exchange is an instrument in writing containing an unconditional order signed by the maker directing a certain person to pay certain sum of money only to or to the order of a certain person or to the bearer of the instrument. So, in promissory note, he himself is to pay the money, but in bill of exchange, the maker is directing a certain person to pay certain sum of money. All of these are unconditional undertakings. Now check. That is in section 6 of the Negotiable Instruments Act 1881. It is a negotiable instrument. According to section 6 of the Act, a check is a bill of exchange drawn on a specified banker. So in bill of exchange, it was direction to a certain person. In check, it is drawn on a specified banker and not expressed to be payable otherwise than on demand. And it includes the electronic image of a truncated check and a check in the electronic form. So that is the main definitions in Negotiable Instruments Act 1881. Then Indian Sale of Goods Act, that is in 1930. A contract of sale of goods means the seller transfers or agrees to transfer the property in goods to the buyer for a price. Section 4 of the Act defines sale of goods. Now, the essential features of sale are: there is a bilateral contract. There must be at least two parties, that is the buyer and the purchaser. Consideration should be in terms of money. Then the contract of sale may be expressed or implied. Then the subject matter of sale must be goods, that is movable property. Then there must be a transfer of property in the goods. Then sale and agreement to sale, both are not the same. In sale, property in goods pass from seller to buyer immediately. In agreement to sell, the transfer of property of goods takes place at a future date. Now there are different types of goods, that is existing goods, future goods and contingent goods. Now with respect to some of the important sections from IPC, that is the elements of crime. The fundamental principle of penal liability is based on the maxim actus non facit reum nisi mensit reum, which means that an act does not become a crime unless done with a guilty mind. The main elements of the crime are actus rea, that is physical act, actus reus, then mens rea, that is mental intention. Then what kind of liabilities are discussed in IPC is vicarious liability, strict or absolute liability, joint or constructive liability. Now the punishment under IPCs that is discussed in section 53, that is death sentence or capital sentence, life imprisonment. So imprisonment can be simple imprisonment or rigorous imprisonment. Then there is solitary confinement. Then there is fine or penalty. Earlier there was transportation for life. Now there is no transportation for life. And then there is also forfeiture of property. Now theories of punishment is retributive theory, deterrent theory, preventive theory and reformative theory. So that is discussed more on jurisprudence. What are these theories about? Then the stages of crime. There are 4 stages of crime, that is intention, preparation, attempt and commission of an offence. Generally, intention and preparation are not offences. However, in some cases, the preparation also becomes an offence. For example, dacoity, waging war, etc. Then general defences under IPC is mistake of facts, that is section 76 and 79, judicial acts, that is 77 and 78. Then we have accidents, section 80, necessity, section 81, infancy, section 82 and 83. In 82 it is doli incapax, that is the child is below the age of 7 years. In 83, that is the child is between the age of 7 and 12. So 83 is not a complete defense. It depends on the mental capability or maturity of the child. Then insanity, that is 84. Then intoxication, that is section 85 and 86. With respect to intoxication, it must not be administered willingly. Then consent is discussed from 87 to 93. Then compulsion is discussed in section 94. Then trifles is discussed in section 95. Then private defense is discussed from section 96 to 106. Then we have communication made in good faith. So that is with the some of the most important sections in IPC. Then we have defamation, we have offences against body, offences against property, offence like from section 299 we have murder, then punishment for murder, then punishment for offense against baby in the unborn child, baby in the womb, etc. There are many important sections in IPC. These are some of the few important ones. So the next is selected topics from administrative law. Definition of administrative law. According to A.V. Dicey, administrative law is the portion of national law which determines the legal status and liabilities of all state officials. Secondly, he defines the rights and liabilities of private individuals in their dealings with public officials. And thirdly, he defines that the procedure by which those rights and liabilities are to be enforced. That is with respect to A.V. Dicey. He has given 3 instances. Now, according to Ivor, Administrative law is the law relating to the administration. According to Casey Davis, administrative law is the law concerning the powers and procedure of administrative agencies, including the law governing the judicial review of administrative action. Now, droit administratif. So, it is also known as the French administrative legal system. Droit administratif. It is established by Napoleon. Droit administration is defined as the body of rules which determines the organization and duties of public administration and regulate the relations of administrative bodies with the citizens. So it is body of rules which determines the organization and duties of public administration, and then it also regulates the relations of administrative bodies with the citizen. There are two sets of parallel codes, that is ordinary codes and administrative codes, that is under droit administrative or French administrative legal system. So this was taken to our Indian legal system. Then delegated legislation. The law-making power is vested upon the legislature. Due to certain reasons, the law-making power is delegated to the executives. The process of delivering the law-making power to the executives are called delegation. Delegated legislations can be classified into two. They are permissible delegation and impermissible delegation. Now there is sub-delegation. The general principle with regards to delegated legislation is that delegates non potest delegare, which means a delegate cannot further delegate. But under certain circumstances, the executives delegate the power of lawmaking to another agency. This is called subdelegation. Now, remedies against administrative activity. That will be private law remedy, then suit against government, injunctions, declarations, etc. Now, there is public law remedy or constitutional remedy. So, these are the writ jurisdiction. That is writ under Article 32 and writ under Article 226. The writ under Article 226 has a wider ambit. Now there is Ombudsman. Ombudsman is machinery against maladministration or corruption. The institution of Ombudsman is intended to act as a check against the abuse of power, non-exercise of power, maladministration, and inconvenience caused due to the delay, indifference, etc. Ombudsman has been found to be very effective machinery for redressing the above grievances. Then there are some theories under administrative law. That is the red light theory, green light theory, and a combination of both, that is the amber light theory. Now, some important topics from Transfer of Property Act. The term notice means the knowledge of the existence of a fact or a state of affair. It is information given by one party to another with regards to a particular matter to another party. Notice can be either express or actual notice, and constructive notice or implied notice. Now, spex successionis. Spex successionis. It means a mere chance of a heir apparent to success to the property of the deceased. On the death of the father, the sole property is inherited by the son. The son is a heir apparent. Son cannot transfer such property during the lifetime of the father. During the lifetime of the father, he is just an heir apparent. He doesn't have ownership of the property. He is expected to receive the ownership of the property after the lifetime of the father. So before having actual ownership of the property, he cannot transfer the property. So that is Peck's successionness. Now, doctrine of acceleration, that is in section 20. If the property interest fails because due to a valid condition not being fulfilled, the subsequent interest is accelerated and taken effect as if the prior interest was never in the way. So there will be an example. We'll give an example. That is, a person keeps a will that his grandson is to have all his property. That is, the will, he says that in the will, the testator says that all his property will go to the grandson. And at that time, there were two of his daughter-in-laws pregnant. Now, one daughter-in-law, like both of them have a probability to inherit the property. But when one daughter-in-law have a miscarriage, that person's interest dies and this subsequently goes to the other daughter-in-law who is still pregnant. So if we are making an interest that you cannot transfer the property to an unborn child directly, it has to be given through a third person, through the life interest of another person. So if there is multiple person in before the child, and if the one person fails to meet any condition, then the will act just as that person did not exist in the first instance. So that is doctrine of acceleration. Then there is doctrine of cypre. Cypre means as near as possible. Section 26 incorporates the doctrine of cypress. That is, a contingent interest is not mere possibility, but a possibility coupled with interest. Then there is doctrine of election, that is in section 35. Election means to choose among alternatives. A person transfers another's property without authority and as a part of the same transaction confers a benefit upon the real owner. The real owner has to elect either to confirm such transfer or to dissent from it. The owner cannot partly confirm and partly dissent. He has to opt it as a whole. Now, the doctrine of holding out. If it is commonly known as transfer of ostensible honor. That is, ostensible honor is not an actual honor, but he has all the qualities of an ownership even though he has no ownership. Now, doctrine of grant feeding the estoppel, that is in section 43. Doctrine of holding out is in section 41 and doctrine of grant feeding the estoppel is in section 43. At the time of transfer, the transferor has no authority to transfer, but misrepresented the fact and induced another person to purchase the property. Subsequently, the transferor acquired the property. Nothing will pass to the transferee because the transaction was void. This is the general principle of law. In certain circumstances, the property acquired by the transferor will pass subsequently to the transferee. The circumstances are as follows. The transferor must have fraudulently transferred the immovable property. The transfer is for consideration. The transferee has not rescinded the transaction. The transferor has become the owner of the property subsequently or has a valid authority to transfer. So in these cases, the property will pass subsequently to the transferee. So that is with doctrine of grant feeding the estoppel. Now, the priority of rights, that is in section 48. Section 48 of the Transfer of Property Act deal with the priority of rights created by the transferor. Now, It is based on the maxim Q prior est tempore potier est jure. Q prior est tempore potier est jure, which means that he who is prior in time is stronger or better in law. It is basic principle under natural justice. Now, the doctrine of equitable estoppel or estoppel by acquiescence, that is in section 51. A transferee who hold a property under defective title and has made some improvements in the property can claim compensation for such improvements. This doctrine assists bona fide holder under defective titles. Now, doctrine of lis pendens, that is in section 52. Doctrine of lis pendens. Lis pendens is based on the maxim pendent lite nil innovator. Pendent lite nil innovator, which means pending litigation, nothing new should be introduced. Now, fraudulent transfers, that is discussed in section 53. A transfer made with an intention to defeat the creditor of the transferor is voidable at the instance of such creditors so defeated or delayed. That is fraudulent transfers, section 53. Now, doctrine of part performance, that is section 53A. Doctrine of part performance. The transfer of property in which the formalities were not completely fulfilled is called a part performance. Now, sale, that is discussed in section 54 to 137. Sale is discussed in section 54 to 137. The transfer of the ownership by the transferor to the transferee for the consideration is called sale. In sale, the transferor transfers all the rights over the property absolutely to the transferee. The next is exchange, that is section 118. Exchange. When two persons mutually transfer the ownership of one thing for the ownership of another, the transaction is called an exchange. Exchange is similar to that of sale. The absolute transfer of ownership is passed from one person to another. And then we have gift, that is in section 122. Gift. Transfer of ownership of movable or immovable property voluntarily without consideration by one person to another is called gift. So generally, most of the sections in Transfer of Property Act discuss about one kind of, that is immovable property, whereas here in gift it is expressly said that is movable or immovable. And in Transfer of Property Act we always discuss about inter vivos, transfer inter vivos, that is both the parties are living members. That is why we don't discuss will here. Now, the parties to the gift are donor and donee. The person who transfers the property is called donor and the person who receives the property is called donee. Then mortgage, that is section 58. Mortgage is defined under section 58 of the Act. It is defined as the transfer of an interest in specific immovable property for the purpose of securing the payment of money advanced by a way of loan, that is as a security for debt, as existing or future debt, or the performance of an engagement which may give rise to a pecuniary liability. The person who transfers the interest is called mortgagor, and the person to whom it is to be transferred or to whom it is transferred is called the mortgagee. Now, there are different types of mortgage, that is simple mortgage, mortgage by conditional sale, then usufructory usufructory mortgage, then mortgage by deposit of title deeds, then English mortgage, then anomalous mortgage. Anomalous mortgage is where one or many of the above mortgage types are combined to form one type of mortgage. Now there is lease. So lease is always a transfer of the right of enjoyment. Now the transfer of right of enjoyment of an immovable property. The enjoyment may be for a particular period. The consideration is called premium or rent. The person who transfers is called lessor. The person to whom the right of enjoyment is transferred is called the lessee. Then with respect to the Indian Easement Act 1882. Indian Easement Act 1882. Easements are the rights connected with the enjoyment of one's own immovable property or others' property. It is called a servitude in Roman law and rights in re aliena in English jurisprudence. So in Roman law it is called servitudes, and in English jurisprudence it's rights in re aliena. Easement is defined under section 4 of the Act. It is defined as an easement is a right which the owner or the occupier of certain land possesses as such for the beneficial enjoyment of that land, to do or continue to do or prevent and continue to prevent something being done in or upon in respect of certain other land not his own. Now there is a dominant holder and servitude holder. Now servient holder and dominant holder with respect to easement. Now the Indian Trust Act of 1882. Indian Trust Act 1882. Trust is the largest and important institution developed in the modern period. Trust is an example of duplicate ownership maintained by two or more than two members. The parties are trustee and the beneficiary. The trustee is the de jure owner and the beneficiary is the de facto owner. The trustee's right is the right in rem, that is the right available against the whole world. The right of the beneficiary is right in personam, that is against the trustee. Now, some of the selected topics from interpretation of statutes. Mnemography. Mnemography is the art of drafting a law. Now, it is derived from the Greek word nomology, which means the science of law. Now, essentials of a statute, that is the long title, short title, preamble, marginal notes, individual sections, definition clause or interpretation clause, provisos, illustrations, miscellaneous provisions clause, repeals or amendments clause, schedule, explanations and punctuations. Now, towards interpretation, we have literal rule of interpretation. It is known as grammatical interpretation or lita legis rule. Lita legis rule, that is literal rule of interpretation. It means words of a statute will give the plain meaning. Then there is logical rule of interpretation. It is called sententia legis rule. Sententia legis rule, that is the logical rule of interpretation. In logical rule of interpretation, the judge must apply his logic in order to get the meaning to the words. Then there is golden rule of interpretation. Golden rule is an extension of the literal rule of interpretation. The court must try to find out the meaning by applying natural meaning. If it leads to the absurdity, the court must modify the meaning to avoid absurd situation. And then we have mischief rule of interpretation. Mischief rule of interpretation was originated from Haydn's case. Before interpreting a statute, judge has to answer the following question. 1. What was the common law before the passing of the statute? Second, what was the defect and mischief for which the law could not provide? Third, what steps were taken by the Parliament to cure the defect? And the fourth, what was the true reason for the mischief? The answer to these questions help the judge to find out the mischief. Then the judge has to give an interpretation so as to suppress the mischief and advance the remedy. Then we have some general principles of interpretation. Now, there is primary rule of interpretation and secondary rule of interpretation. The literal rule, logical rule, golden rule, and mischief rule are all primary rule. Now there are secondary rule of interpretation. That is also known as general principles of interpretation. So these are nocita a sources rule, harmonious construction, ut res magis valeat quam periet, ut res magis valeat quam periet. Then redendo singula singulis, then in pari materia, ejusdem generis rule, ex viceribus actus, then contemporaneous expositio, then generalia specialibus non derogat. Now what are these? Nocita a sources rule. It means a doubtful word may be ascertained by means of ascertaining the meaning of the words associated with it. So, if you have an ambiguity of the meaning of a word, the meaning is derived or ascertained by understanding the meaning of the words associated with it. That is nocita a sources rule. It is an application of ejusdem generis rule. Now, harmonious construction. The different provisions in the same statute contradictory to each other, the court will try to give the meaning so as to maintain a harmony between the different parts of the statute in order to minimize conflicts. Then, ut res magis valeat quam periet. Ut res magis valeat quam periet. It means that the thing may have effect rather than be destroyed. Two possible interpretations are available to the judge. They are: 1. It gives color and life to the provisions, and 2. It renders the provision void. Then the judge must resort to the one that gives color and life to the provisions. That is ut res magis valeat quam periet. That is, it may have effect rather than be destroyed. Then redendo singula singulis. While interpreting, the sequence or arrangements of the words must be considered. According to Lord Crawford, to read without breaks and stop, they would not be clear. Then in pari materia. Statutes are said to be in pari materia if they are having the same subject matter. In such cases, the meaning given for a word in a statute can be given in other statute. So that is where we use the general clauses rule, or we refer to the definition of will, definition of dowry. So we discussed dowry death in IPC, but the definition of dowry is given in Dowry Prohibition Act. Same way. According to Maxwell, statutes are said to be in pari material when they deal with the same person or thing or class. Then there is ejusdem generis rule. It means of the same kind or species. The word gets its meaning from the company it gives. The following are the essentials of application of this principle. The first, the statutes must contain enumeration. There should be a listing out. Then the enumerated things must constitute a class by itself. So when you say pen, pencil, eraser, sharpener, this belongs to a class of stationery. So there is a listing and it should belong to a class. Then the general term should the enumeration. The class must contain several items. So these are the essentials to apply the adjusted generalist rule. So if you say that the public officers like collector, police officer, etc., then we have ex viceribus actus. A word gets its meaning from the context in which it appears. When the statutes is read as whole, because a word might have different meaning when used in different context. So the meaning of the word should be understood in the context it is used. So for example, in a case, the person says that he slept in my room, and another statement that he slept with me. So both has a different meaning. So he slept in my room is literally that the person did sleep in that room. But he slept with me means that the person had a sexual intercourse with the other. So that is, the word should be understood in the context it's used. Then, contemporaneous expositive. A word must be given the meaning as given at the time of making the statutes. This principle is applicable while interpreting ancient statutes. It is not applicable in modern statutes. Then we have generalia specialibus non derogant. That is, general things do not derive from special things. So if there is two statutes, which is a general statute and a special statute, then the special statute will prevail over the general one. So that is generalia specialibus non derogant. Now, with respect to the aids of interpretation, again we have primary aids as well as secondary aids. So also known as the internal aids and external aids. So the internal aids are the what is found in the statute itself. That is the long title, preamble, short title, then the definition clause, headings, proviso, marginal notes, exceptions and saving clause, legal fictions, explanations, illustrations, punctuations, etc. And the external aid is when we refer to the dictionary, such as we refer to the Blackburn Dictionary or the Collins English Dictionary. So the dictionary, the foreign decisions, debates and discussions in the parliament, constitutional assembly debates. When we refer to these, it is the external aids. So that is with the interpretation of statutes. So next we are going to discuss some of the topics from cyber law. So first definition we are going to look is access, that is section 2, clause 1, subclause A. Access, with its grammatical variation and cognate expression, means gaining entry into, instructing, or communicating with the logical, arithmetical, or memory function resources of a computer, computer system, or computer network. So it is entry into, instructing, or communicating with logical, arithmetical, or memory functions or resources of a computer. That can be computer, computer system, or computer network. So that is access, defined in section 2, clause 1, subclause A. Then addressee, that is section 2, clause 1, subclause B. Addressee means a person who is intended by the originator to receive the electronic record but does not include any intermediary. Now, adjudicating officer. Adjudicating officer means an adjudicated officer appointed under section 46, subsection 1. And then we have asymmetric crypto system, that is section 2, clause 1, clause F. That is section 2, clause 1, subclause F. Asymmetric crypto system means a system of a secure key pair consisting of a private key for containing a digital signature and a public key to verify the digital signature. The next we have is certifying authority, that is section 2, clause 1, subclause G. Certifying authority means a person who has been granted a license to issue a electronic signature certificate under section 24. Then there is computer, that is section 2, clause 1, subclause B. Computer means any electronic, magnetic, optical, or other high-speed data processing device or system which performs logical, arithmetic, and memory functions by manipulation of electronic, magnetic, or optical impulses and includes all input, output, processing, storage, computer software, or communication facilities which are connected to or related to the computer in a computer system or computer network. Then there is computer system, that is section 2, clause 1, subclause L. Computer system means a complete working computer, including the computer along with software and peripheral devices such as printer, scanner, or routers that are necessary to make the computer functions. Now, computer network, that is in section 2, clause 1, subclause J. It is a collection of computers and devices interconnected by communication channels that facilitates communication among users and allows users to share resources. Now, computer resource, that is section 2, clause 1, subclause K. Computer resource means computer, communicate devices, computer system, computer network, data, computer database, or software. This term covers the terms computer, computer system, internet, data, database, and software. The next one is cyber cafe. That is defined in section 2, clause 1, subclause NA. Subclause NA. Cyber cafe means any facility from where access to the internet is offered by any person or the ordinary course of business to members of the public. The next is digital signature, that is defined in section 2, clause 1, subclause B. Section 2, clause 1, subclause B. Digital signature means authentication of any electronic record by a subscriber by means of an electronic method or procedure in accordance with the provisions of section 3. So, it means authentication of any electronic record. It's the process of authenticating by a subscriber by means of an electronic method or procedure in accordance with provision of section 3. Now, that is digital signature. Then we have electronic signature. That is section 2, clause 1, subclause TA. Section 2, clause 1, subclause TA. Electronic signature means authentication of any electronic record by a subscriber by means of electronic techniques specified in the schedule and includes digital signature. So, electronic signature also include digital signature. Now, electronic signature certificate. Electronic signature certificate given in section 2, clause 1, subclause TB. Electronic signature certificate means an electronic signature certificate issued under section 35 and includes the digital signature certificate. Subscriber. Section 2, clause 1, subclause ZG defines subscriber. Subscriber means a person in whose name the electronic signature is certified to. Cyber defamation. Cyber defamation involves the publication of statements to lower the reputation of a person. Then there is email bombing. In internet usage, an email bomb is a form of net abuse consisting of sending huge volume of emails to an address in an attempt to overflow the mailbox. Now, cyberspace. The term cyberspace was coined by William Gibson in 1980 in his science fiction novel Neuromancer to describe the environment or space within computer hackers' operation. So it was first coined by William Gibson in 1980 in his science fiction novel Neuromancer to describe the environment or space within computer hackers' operation. So that is with cyber laws. Now towards some of the important labor laws. So the important labor laws we have is Factories Act 1948, Employee State Insurance Act 1948, Workmen's Compensation Act 1923. Right now it is also known as the by 2009 amendment, it is known as Employee Compensation Act 1923. Then Minimum Wages Act 1948, Payment of Wages Act 1936, Payment of Bonus Act 1965, Payment of Gratuity Act 1972, Employee Provident Fund Act 1952, Maternity Benefits Act 1961, then Kerala Shops and Commercial Establishments Act 1960, Industrial Disputes Act 1947, Trade Union Act 1926, then Industrial Employment Standing Order Act 1946. Now, with respect to the labor laws, the term award means any interim or final determination of any industrial dispute by labor court, industrial tribunal or national tribunal. The term also includes an award by an arbitrator. Now, public utility service, that is given in section 2 clause N of the Factories Act. Now, it means and includes railway service or any transport service by air, any service in connection with any port or deck, postal, telegraph and telephone services, etc. Now, strike and illegal strike. Now, strike is a weapon in the hands of the workers to enforce their demand against the employer. It is the cessation of the work by the employees for any length of time under a common understanding to put pressure on the employer to accept their demands. The strike conducted in violation of the provisions of the Act is termed as illegal strike. Then there is lockout and illegal lockout. Now, lockout, it is a weapon in the hands of the employer to enforce his demand against the employees. So, strike is a weapon in the hands of the workers or employees, and lockout is a weapon in the hands of the employers against employees. Lockout means the temporary closure of a place of employment or the suspension of work by the employer or refusal by an employer to continue employ persons employed by him. If it violates the provisions of the Act, it is called illegal lockout. Then there is layoff. The refusal or failure or inability of an employer to give work to a workman is called layoff. So layoff can be for half day or a full day. And the laid off days are counted for the number of days in service. Then there is retrenchment. Termination of service by the employer for any reason otherwise than as punishment inflicted by way of disciplinary action is called retrenchment. Now, unfair labor practice. Certain practices are deemed to be unfair under Schedule 5 of the Act. The Act prescribes penalties for the same. Then there is collective bargaining. This is one of the major aims of Industrial Disputes Act 1947. The term has been coined by Beatrice Webb. Collective bargaining is a negotiation between the employer and employee to reach an amicable settlement on working condition. So that is with the session. We discussed about few of the statute topics that was short. So I hope this is helpful. If there is any comment, please put it. Any feedback, please put it in the comment box. And if you like this, please like and comment. If you have not subscribed to my channel, please subscribe. Thank you and have a nice day.